This next covers patenting and the patent process. As in research, a patent is required to be new and useful, and it's also required to be inventive, which means that it has to be non-obvious. It's possible to patent things and processes and improvements on any thing or process. So it's not just things that get patented. Patents are issued by governments, and they give the inventor the right to make, use, or sell the invention claimed in the patent exclusively. In Canada, patents now expire 20 years after the application was filed. In Canada as well, the patents are actually managed at the federal level. The Federal Patent Act governs them. And it's the responsibility of the federal court to ensure that Canadian patents are enforced. In terms of patentable idea being new, basically the idea cannot have been disclosed in a public forum previously, all the information required to meet the patent. There are certain specifics on that. The applicant can have up to a year from a first public declaration to file. If anybody else publishes details about a patent other than the filer, then that would generally prevent that patent from being approved. And if the patent has been filed previously by somebody else, that would be the best reason to block a new patent application. So if a patent fails its novelty aspect, it's generally referred to as anticipation. This means that the idea has been previously available in the public in a way that failed the previous tests. So there's an 8-part test for anticipation. Anything that previously describes a concept has to give an exact description. Descriptions which will result in development of the key parts of the invention. Those directions have to be clear and unmistakable. The information has to be equivalent to what's in the proposed patent. It has to be in a way that if you were a non-expert, you would recognize that the two ideas were effectively the same. And the aspects of a patent have to be met in a single document. So you can't have many pieces that would ultimately create the content of a new patent. So the test for non-obviousness is fairly well defined as well. If you take somebody who is an expert in a particular field with no particular strong imagination, and through general knowledge of that field at the time of application, they would be able to come up with an invention with not too much difficulty, then that would be deemed obvious and would not meet the criteria. And the final test is that of utility. So it's not possible to patent something that doesn't in some way serve some use. That doesn't generally prove too difficult to meet, but if there was something developed that had no use whatsoever, it would fail the utility test. So in terms of what can be patented, it's worth noting a few exceptions. And in particular, when it comes to an algorithm, that would not be patentable, but the software that might use an algorithm could be. The algorithm itself may be able to be copyrighted. So as we mentioned earlier, it's important to be the first one to file a patent in a given area, because if there is a previous patent filing, that will trump any current filing. So there's often a race to the patent office if there's a new idea that emerges. There's also this concept of a 1-year grace period, so inventors can file for a patent within a year of their first public disclosure. However, disclosing to the public before filing could limit international patent opportunities. It is possible to change the actual date of filing if, for example, you have filed in another jurisdiction in order to achieve the first to file. So, for example, if you file a patent in the US, you then file in Canada a few months later, but somebody beat you to the post in Canada by a few weeks. If your US patent filing was still first, then the earlier filing date could apply. In Canada, 18 months after you've filed, unless you withdraw your patent, the application is made public. This will protect you, but it also means that everybody else knows your idea, and that's when your clock is effectively ticking towards benefiting from your commercial idea. You have 15 years from filing to benefit from it before anybody else can make use of that. You typically use or have to use a patent agent to do the filing. They file patent applications on your behalf. They will do searches to make sure that the application should be successful. Once a patent is approved, then any infringement can be pursued under law. And infringement is not just somebody copying your idea. It could be somebody using or selling the invention without your permission. It could be somebody possessing something that holds that patent, or using a patented object in a process that hasn't been authorized. So some key things in terms of capturing your invention to ensure that you're likely to be successful in an application or a complaint against an application. Do keep notes on your invention in notebooks, keep them signed and dated, make sure that you write them in ink. Do not leave any blank spaces which could be open to interpretation. Do not remove any pages from your notebooks. Make sure that you record any minutes of meetings or any experiments that you do, and obviously make sure you keep the notebooks themselves. There are times when a patent may not be appropriate, however. In particular, if there's a lot of previous inventions in the area, it may be difficult to prove novelty. If it's going to be difficult to enforce the rights that you're trying to establish, and so you'll end up having to pursue lots of people, that can be a bad reason to file a patent. It might be better to keep the idea secret. If you don't know how you're going to make money off the idea, then patenting may again not be good, because that 15-year timeline could expire before you've actually reached the benefits, and everybody else will then be able to jump in very quickly. If you're only able to protect a small piece of your invention through a patent because the rest of it may be in the public domain, then that might be a reason not to file a patent, because your small piece may be the commercial advantage you're trying to achieve. And if you file too soon, again, because of the ticking clock, that could cause you to not be able to gain as much benefit from filing as if you file just at the right time.